of some persons in Yaoundé by a magistrate in Yaoundé, and later on that same magistrate is seen as having signed another decision referring to what previously I watched on media, social media as fake, noting that 2 weeks ago we saw the President of the National Assembly sign a decision that was read over national radio, only for that same decision to be refuted by another decision still signed by the President of National Assembly. And we're going to be looking at what is not working well with the way things are happening in Yaoundé, and we are going to be looking at these decisions with Senior Barrister Ashu Emmanuel, who will explain better how these things work, also making us understand whether it could be truly fake or not. We also are expecting the Undersecretary for Communication of the Cameroon Renaissance Movement to join us. We're talking about Fah Elvis Tayong. We also are expecting the arrival into our studio of the representative of the CPDM, Mr. Siaka Shunneh. They should be caught in traffic, but we're starting with Senior Barrister, who is an expert in the domain. Good evening, Senior Barrister. We're glad to have you.
Good evening, Mr. Kum. Good evening to all the televiewers of My Media Prime worldwide. Good evening to all the militants and sympathizers of Reform Party at home and abroad, Germany. Good evening.
Okay, we have here, I'll start with what took place. That was on the 1st of December. Procedural, the notification d'une ordonnance au Conseil, that is signed by Jean Didier, who is a greffier. Greffier should be the
registrar.
Registrar, is it not?
Registrar.
Yes, the court registrar. And then we have this other one, yes, by him, by the court registrar. But we have this one signed by the magistrate Sikati to Camo, which is okay, who actually informs that there was going to be some releases of some 2 high-profile personalities in the country. How, and later on we are told that these were fake. How fake were they?
Thank you, Mr. Kum. You see, the law is tough, but it is a law. It has to be applied as it is.
Yeah.
And this news of the fakeness, the supposed fakeness of this document came from the purported author,
the judge, Sikati,
the purported author, and this has raised indignation nationwide, because many people say, how can a judge issue an order and then swallow his vomit? Now, I think we have to be very clear on this. This is a purely legal issue, and I think people have to understand exactly what is happening.
Okay.
This judge, in my opinion, did not swallow his vomit. If you look at the provisions of sections 153 to 165 of the Criminal Procedure Code, they clearly define what becomes of documents or judgments issued by the examining magistrate. Those, when you go through, especially 153, the examining magistrate must be assisted, must be accompanied in whatever order he is signing by the registrar in attendance. The registrar must countersign the order for it to be valid. You see, all the documents you are talking of, I've seen the notification, but my colleagues were foolish enough, my colleagues who are now complaining, they were foolish enough to accept notification of an order that was not countersigned by the registrar. Because if you put that order side by side with the provisions of section 153, you will see that the registrar did not countersign the order, and as such, it is the order, the ordonnance,
the mise en liberté,
the order
by the judge.
It was supposed to be countersigned by the registrar in attendance.
Yeah, but we have
for it to be valid.
Where we have a procès verbal de notification d'une ordonnance au conseil. This one is signed by the registrar.
What I am saying, I am saying that the examining magistrate cannot alone sign an order, and his registrar doesn't sign. He has to sign, and the registrar has to countersign, because 153 says that he is assisted by the registrar. What I am saying has been forcefully presented by big legal minds. Chief Justice Fongang of the Supreme Court, who is presently president of the Supreme Court, in a book that he wrote with Mr. Ewane Ashu, the State Counsel of Manfe. I don't know if you can say it. That is it. Okay. Herein they have reiterated this. Well, their book is in French, but it is clear. See, à l'exception des mandats résultant de l'impérium du magistrat, with the exceptions of warrants that pertain to the magistrate's imperium, toutes les décisions, tous les rapports et toutes les déclarations enregistrées, all decisions, all reports, and all declarations registered during judicial inquiry doivent être signés par le greffier, must be signed by the registrar et le juge d'instruction and the examining magistrate. Si un procès verbal ou une déclaration enregistrée au cours de l'information judiciaire ou une ordonnance du juge d'instruction, if a report or a declaration or statements taken down in the course of judicial proceedings, in the course of judicial inquiry, or an order of the examining magistrate is not countersigned by the registrar, l'audit act est consideré comme nul et non avenu. That document is considered null and void. And there is jurisprudence to this effect, sir. We have reported cases. Like, you see, there are two reported cases that they have cited. From the Northwest, the case of Ma Felix team against the people. Then the second one is the case of the people against Ngefi Caroline. And the court in these cases held that orders of the examining magistrate must be countersigned by the registrar, otherwise they are null and void.
Yes, so, but, okay.
So if we go by this, if the examining magistrate sign an order and the person who is supposed to authenticate the order by his signature doesn't sign, is that order valid or invalid?
Now, what about this procès verbal?
I am coming, sir.
Okay.
You cannot, if you notify a nullity, a non-entity, does it exist? You cannot notify something that is void at law.
Is this same registrar that was supposed to countersign?
Yes, he was supposed to countersign. Yeah, but he didn't.
But he has written.
He was supposed to countersign the order, sir. The fact that he has
what nullifies it is the mere fact that he did not
countersign the order.
Even if this came from the examining.
Yes, sir. He was supposed to countersign. The fact that he didn't countersign renders that order null and void. And if it is null and void, it is as good as fake.
Okay, it is as good as fake. Are you saying that the examining judge only came to issue that communique because he discovered that there was an error, that the order
possibly was not, because an order that was not countersigned by the registrar was served on the parties. So it's
now this what does this serve? Procès verbal de notification d'une ordonnance au conseil. What was the essence of this?
By that document, it was supposed to be the service of the order
of this order
of that order on the lawyers of the parties. But unfortunately, they were serving that document is serving an invalid order, an order which is invalid at law. So it is a non-entity. It's a nullity. There's no need for.
Yeah. but at least this document, because here we have communiqué de presse des collectifs des avocats de M. Eco Leopold Maxime, acknowledging the fact that they have received this, I'm sure.
I agree.
Yeah.
They received something that is invalid. So how good is it?
Invalid, but coming from the competent authority.
It is invalid at law because it does not contain the required signatures. What did it cost this registrar to countersign that order? What? They made a mistake and went and served it, and the magistrate realized it later, say, hey, if this thing goes out like this, it's a violation of the law, so please, it's invalid.
Which means that
the magistrate did not declare it invalid. It is the law.
You are looking at it from the legal perspective, but let us look at the fact that these authorities, is it possible that they actually gave the orders for their liberation?
Mr. Kum,
without taking a note.
I don't want to go into the file. I am not I'm not a lawyer in that file. I don't know the facts. I am saying that we are
not talking the fact.
Yes, I am saying that
the fact is that this is an order signed by the examining magistrate. This is an order Procedural signed by the registrar. Now,
his registrar.
Yes, his registrar.
His registrar. Yeah.
Yes, these are persons who are working together.
Yep.
Yes. So are we saying that they may have issued these documents to the lawyers, because the lawyer of one party and the lawyer of the other party, two persons were supposed to be released. Both lawyers acknowledge receiving this information, and they have documents that actually it shows that they call it what, I don't know. Yes,
Mr. Kum, the lawyers ought to have been vigilant not to receive a nullity. You see,
yeah, but
at the time when they were called to come and receive this document, they ought to have noticed that it was not countersigned by the registrar. And at law, if a document from the examining magistrate is not countersigned by the registrar, it is invalid. That's the thing.
Yeah, but the question now is, why would the examining magistrate, in this case, and the registrar issue a document, and then these lawyers received the document? Because the fact is, it is coming from you guys, whether it is final.
I want to make this clear.
Yes.
You see, if you are used to the courts, the magistrate would certainly had signed this document, certainly, and left. It was incumbent on the registrar to countersign. He didn't. He forgot. He must have forgotten. And the one accepted it. You see, look, I don't think that
Magistrate Chungang and the other.
They were not vigilant.
But would they lie that they received this document?
They were not vigilant, sir. Yeah. I am saying that the fact that a document that was improperly signed was served on them poses a problem, because at law that document is a nullity. So the magistrate was right to say that it is fake, because since it is a legal nullity, it is as good as fake.
Now, if it is fake, who gave out this information?
The registrar is to blame here, sir, because before serving this document on the lawyers, he was supposed to countersign it. He didn't. He is to blame.
Which means that
the registrar in attendance is to blame, because
which means that the documents were authentic but erroneous because someone failed to sign.
Lacked validity because the second signatory did not sign.
Now, going by what you're saying, it means there was a decision arrived at for persons to be liberated.
You can see it. You can see it. If that second signature were there, the language would have been different, because it would have complied with the law, and nobody would have had anything to say. Not even the presidency would have raised a finger, because the law says that it is only an appeal against that order. You can only go and appeal to the control chambers, inquiry control chambers. You cannot contest it. But the fact that a document that was improperly prepared was served out poses a problem, because if these people were to be released, they would have been released on the basis of a document that was not proper at law.
And now, what is the procedure that is supposed to run through for the examining magistrate to arrive at this decision?
Well, the examining magistrate must have heard all the parties. If you look at the order, the order that was issued, therein it is mentioned that he had heard the parties. Somebody cleared those two people, and there was no reason for him to continue keeping them. So he had gone through the investigation, and apparently, I think he finds that there is.
Was there not supposed to be a hearing, or either a day prior to this or this same day? Were they not supposed to appear before the examining magistrate before this?
The examining magistrate is telling you there that he actually heard them.
Okay.
He actually heard them, and from the statements of one of the accused, those two were cleared. So he doesn't have any reason to continue keeping them.
Now, but when the examining magistrate, this same magistrate who signed this, comes out to say this information is false, I don't know, is it not also indicative of the fact that maybe pressure came from someone?
I am saying that the fact that that document does not bear the requisite signatures, because you see, the registered in attendance is not a figurehead. He is the person whose signature authenticates that document. If it is lacking, the document is null and void. And if it is null and void, it is as good as fake. You see? So if this man realizes that what he prepared was not properly served,
which means that if we go by what you are saying and not by what some other quarters are saying, that maybe we have some persons who ask for that information to be nullified. You saw what happened with the President of the National Assembly, who actually signed a document that was read over national radio, only to sign another document, the same President of the National Assembly, saying that the previous one was false or fake, like we are now talking about, which means that in the days ahead, proper justice is going to be done.
It's very possible.
If we go by what you're saying,
it's very possible. I am saying that that document is defective at law and is as good as fake.
Yeah, but why do you want to also think that there may be some battles at some quarters?
Because I am not privy to those battles. I am not privy to whatever intervention there can be in this type of case. Because before a magistrate of that caliber takes his pen to write, he must have consulted his hierarchy and agreed, obtain their permission to come up with this type of thing. So I don't think I will buy the idea that there is some instruction coming from anywhere.
You wouldn't agree that some instructions came from anywhere, to say that our judiciary is very independent and nobody from the executive can influence their decision? Is that what you're saying here?
Well, in the case of the examining magistrate, this is a very powerful magistrate. You see, many people don't know this. The examining magistrate, whether he is attached to the court of first instance, the High Court, the Military Tribunal, or the Court of Appeal, this is a very powerful magistrate. In fact, he is a person who can even send people abroad to go bring information. So the law doesn't know any control, any administrative control of his actions. The law doesn't know that. The law only knows control by the inquiry control chambers. If you don't agree with whatever he has come up with, then appeal to the inquiry control chambers and have that decision modified.
Okay.
So if an administrator were to step in to cause this judge to change his opinion, it would have been terrible. Because if, as I'm saying, if that document bore the counter signature of the registrar, it would have been terrible for any person to say it's a fake.
If what you are saying here today, senior barrister, is true, are you saying that in the next 2-3 weeks we're going to see these persons released because they are there simply because of an error made by the registrar?
With all my years of experience, when I see this, I am very certain in no distant future they will be released.
Okay, they'll be released, and
a registrar cannot take up, because let us assume that the order was fake. Were the notifications too fake? I'm giving you legal reasons why the judge could have said that thing was fake, because it was improperly done.
When you say it is fake, and we have the lawyers who are your colleagues actually saying that there is something political behind this decision, this U-turn taken by the examining magistrate, is it that they don't understand the law as you do?
My brother, I said earlier that my colleagues were negligent. They didn't examine the document that was being served on them. If you were to call me to come and discharge that type of document, I won't take it if it is not countersigned, because it won't be valid.
Okay.
So they should not cover their negligence with rhetoric or accusations that cannot be backed.
Why don't you also think that some persons may have instructed or informed that the presidency wants these guys released, only to discover that people are using the presidency to manipulate some of the decisions? Because
the presidency has no way to influence the decision of the examining magistrate.
Okay.
Mr. Kum, you see, if the presidency, in my opinion, if the presidency wanted this examining magistrate not to issue that order, I don't think he would have had the courage to even write. Because one is a military magistrate. He has a high command, which is up there the presidency. We all know that his minister is a minister delegate. So the real minister of defense is who? The president of the republic. So no, I want us to look at it well. The real minister of defense is the president of the republic. The minister of defense is a minister delegate. Now, if the president of the republic wanted this man not to write anything, he would not have had the courage to go and sit and write anything. I think that they didn't want to cause confusion by when they noticed that there was an error, and this thing has to be corrected before it can be made public.
When you say if he knew that the presidency was not okay with this decision, he would not have gone ahead with it.
I think so.
Yes, but how do you say if he knew that the presidency was and claimed that they are independent enough, when you know they have to? Yes.
Mr. Kum, I want to remind you that this file, the complaint was filed by the president of the republic, right?
Yes, yes.
You remember? The complaint was filed by the president. The investigation was supervised by him, and after that, it was sent to the examining magistrate. So then, on top of that, the examining magistrate is a military man, and I am telling you, I'm reminding you that the military man has as big boss the president of the republic, who is the real minister of defense. So, I mean, there is no way you can say that this military man.
Now, if the big boss is the president of the republic, why don't you feel that information got to their level that the president of the republic wants these guys out, only to discover later that the information was not true?
That is not possible, because
what happened? What happened?
It's not possible because
what happened with the case of the president of the National Assembly who signed?
It's not the same thing.
Encounters. Yeah,
it's not the same thing. This one is a case where the president said, "I am ordering investigation." The investigation was carried out under his supervision. So anything happening there, they report to him. We know how this country functions. They report back to him. So I don't see any magistrate who, knowing that he is handling this type of file, will take upon himself to go make that type of order. I don't see. It's not feasible. There is, you see, I want to look at the other part of it. Had this magistrate not said that the order is fake, do you think on the face of it, it would have been enforced?
Why would it not be enforced?
It does not bear the signature of the registrar, so it is not proper at law. It's not. I've given you the legal backing. It's not proper at law. So look, let me tell you, you have read letters. You did not read the one letter of the military prosecutor. The military prosecutor also wrote to the superintendent of prisons asking him not to enforce. You
yes,
understand?
yes, but that came after information. Another order was given claiming that these letters are fake.
Yes. Because
when you say it is fake, what is fake in it?
Because
you are saying that
lawyer,
you are saying that there is an error.
It is bad at law,
yes.
and if it is bad at law, it's as good as fake.
Is it the same as fake?
Yes, there is a nullity. It's a nullity, so it is as good as fake. That's what I'm saying.
No, when you say fake, how fake is it? Fake means that something is crafted by some persons to give a semblance as coming from us. This is not the case, going by what you're saying, because you say it is coming from the competent authorities, but it's faulty because the registrar
does not countersign.
Yes, is it the same as being fake? Because we may have made an error. We may say that this document is faulty, but it is different as being fake, because fake means that some person sat somewhere, like what happens in Kumba. This document was done in Bonas. That is the sense that we have here. That these documents were crafted in Bonas, in computers, and circulated, because it says the information that is circulating, documents that are circulating on social media. How fake are these documents?
No, Mr. Kum, if they were crafted elsewhere, the registrar in attendance will not have them served on the parties.
Yes, so
they are from the court.
Yes, so how
I am saying that, in my opinion, the problem is that the document is defective at law.
And not fake.
It's defective at law. It's a legal nullity. And if it is a nullity, then it's as good as fake. Maybe they didn't use the right term. But I am saying that being a legal nullity, that is, at law, it does not exist at all. If it does not exist at law, then it is as good as fake. I want to think that the prosecutor didn't use the right word to qualify what happened there, because without even that letter, I don't see any person enforcing that thing. I don't see any person enforcing that order, because we all know that for an order like that to be enforced, it must be countersigned by the registrar, because the law says whatever the examining magistrate produces has to be countersigned by his registrar. Which means that there is also, I'm standing by you. When the magistrate, examining magistrate comes out to say the information that is circulating on social media is fake, it means it does not come from him. That is what we are saying. And you say it is coming from him, but there was an error. If he says that invalidates everything.
Yes, that is what you are saying.
Yes,
but that's what he says. But that's not what he's saying. I am saying that his choice of words may not be proper, but let us go by what he is saying. Yes, it is fake, meaning that some guys may have sat somewhere and came up with something, which means he is saying that the decisions arrived at, as explained by this document, are fake, which means these guys are supposed to stay behind bars. No, that's the consequence of that is what by fakeness of this document. No, if they are supposed to stay behind bars because the document cannot be enforced, right? Because that document cannot be enforced. Why can it not be enforced? It cannot be enforced because it does not it does not stand the test of the law. Okay. And it doesn't stand the test of the law because it is defective. I am saying that this man used words that may not have been correct. He said fake. I, a lawyer, cannot buy the fakeness because it was served on the lawyers by his registrar, who is an officer of the court. It was served by an officer of the court. What I find as a problem is that the document was defective at law. The law says this man must be assisted by a registrar, and from all the decided cases on that issue, if any document, any order is made by the examining magistrate, and you say, and his register does not countersign, it is null and void. And you say our justice is very independent. That's what you say. Yes, that's what you said. I said the examining magistrate is a it's a very powerful magistrate and cannot be influenced by the law doesn't permit that. But you just said the president is his boss.
Why? But this is a military magistrate now. It's a military. It's a soldier. A soldier in a military tribunal with the Minister of Defense who is up there as a boss. Who promotes him? Is it not the president? The president is his boss. You cannot deny that.
The president can
give orders
on what he does.
Now, Mr. Kum, let us understand this. On the other side, people are saying that orders came from the presidency. I am saying I don't think any order came from the presidency.
Okay.
Because if orders were to come from the presidency, they would have preceded the order. Orders would not have come after. Because a man handling a type of delicate matter cannot take upon himself to pen that type of thing without clearance.
I ask again, you know, at the presidency, there are persons handling specific positions and responsibilities. Why don't you think that an order may have come from one quarter of the presidency telling him that this is what the big man says, only for the big man to say this information and discovers that I did not give this order?
That one is delicate because, first of all, this is a matter that is supposed to be handled in secret.
Okay.
We are not in the secret of the gods. You see, we are not in that secret, so we cannot go imagining.
Yes, we have just been joined by Fah Elvis Tayong, who was caught in traffic, and we glad you are here. When you look at this, the senior barrister says this guy is a super scale. He cannot just be ordered around. This information is the documents that we are talking about are faulty because it was not countersigned, and that also says that it is not. It is
countersigned by the registrar in attendance.
Yes,
as required by the law.
Are you following up with what is happening, the kangaroo man?
Well, I'm following. I'm not a jurist, but I followed keenly, and from every indication, I think that, as I said, there's no smoke without fire, and we might be able to put the points from different directions, putting in place the legal parameters. But one thing is for sure that with the Cameroon legal system, we must be able to admit that there are some cases that don't go through the due process as per se. We could quote the laws from Article 1 to this and that, but we understand that in practical terms, it is one of the few countries in the world whereby things are done differently away from what is there now. What am I saying? If you have a case, for example, like as such, which is probably very sensitive, where you have different hands, probably having a hand in it or an eye on it, it becomes very sensitive, and so you would get some of those parameters of the law being applied. But at the same time, if you have cases like these, or maybe different from this, which could equally be light-weighted, you realize that most of the times, then now the due process of the law comes in. If it is a man who stole plantains from somewhere, or the common armed robber probably at Mbopi, who was caught with firearms, no, that one is very sure, it's very clear. At the military tribunals, you then discover that the examining magistrate has a full say on that kind of the case, irrespective of whether the president is making an input in it or not. So, but then, let's come back to the case of Martinez Zogo. We understand that it's a tricky one. Why? Because the manner in which he was brutally murdered, and the case itself has actually been able to arouse the interest of almost all Cameroonians from different spheres of life. It now means that from the way the case is unfolding, it is not just an ordinary case compared to any other military case that we could find around. Maybe you are accused of being a secessionist or accused of using firearms and all the like. Now, if you look at it critically, when I saw the communique and the counter one still coming in from that same court, I said, but something is wrong somewhere, because someone was actually trying to play fast along the line. Then now you could understand that they will tell you the examining magistrate is quite very dependent and all the like, but you understand that another counter information from that came from the president, himself. Now,
the same person signs an ordinance de mise en liberté, informs that these guys should be released.
Yes.
Later on, the same person signs and claiming that what has been circulating is fake.
Yes, there's another one again from the president who is instructing the registrar of the prison, of the central prison in Nolinga.
The public prosecutor.
The public prosecutor, correct, informing him not to take any action if he has not seen anything passing through the due process. Now you understand that from every indication, as I said, it is a sensitive one, and we must be able to understand that there's no smoke without fire. no matter how we take the case, we analyze from left to right, one thing is for sure, that someone was playing fast somewhere.
Let's assume that the documents are fake.
Yep.
Who would muster that courage to come up with fake documents and then hand the fake documents to the registrar, who now calls the lawyers of both parties to come and discharge? Because these letters were discharged.
Yes, that's why I'm saying that from every indication, the case is further than the way we are looking at it. And as I said, if the judicial system is serious, they are supposed to investigate even the lawyers of those who are guilty, because they actually came in. Barrister will understand what I'm talking about. No matter how you say you discharge,
they discharged and they issued a press statement.
And a press statement to that matter, because I've seen Mete Chungan signed somewhere along the line. So, but what I'm saying is that, Mr. Liu, no matter how the issue is transpiring, we understand that someone was playing fast. Now, and someone wants to vindicate his or herself to play another fast move. But I think that a due process of investigation, independent, is supposed to be launched on this, so that we will be able to know who was the master planner of this, because this is a high level of a kind of mafia. Because you and I, being low the way we are, cannot muster that kind of courage. It means that for that kind of courage to be mustered, there must be invisible hands. It's the same like what we talked about the death of Machide Zogo. We said, why is it trending in a different direction? Because invisible hands could have equally been involved in it, such that taking it as per se. Now, barrister is who understands. If you look at senior barrister, sorry, if you look at the initial file that sent them to jail, you discover that murder is not there. It has to do with torture. It has to do with torture from the initial. So you still see that something is still wrong, because if you torture somebody and he dies, torture could be part of it, but the other part of suspected murder is supposed to accompany, because the act of torturing leads to death as per se. But now if you look at what is transpiring here, as per what sent them to the prison, the issue of being suspected murderers is not even there at all. It is an aspect of torture. So you realize that somewhere along the line, the justice is still being thwarted. But then I will tell you clean and clear that someone was testing the waters, and because the waters became too hot, they had to backpedal in order to take another move or have time to rethink. But this is the time Yaoundé should understand and listen very well. If you want to tell us that this case will be as transparent as what you need, first we should go into the nitty-gritties to find out those invisible hands that were behind this, because it was discharged.
Yes. Senior barrister, who would muster this courage to come up with such a game? Because if we consider that this is fake, how do you play with a case like this?
Well, when I was explaining, Mr. Kangaruma was not around. You see, first of all, I speak as a lawyer, and I give the legal backing of whatever I'm saying. You see, we are examining the order of an examining magistrate who decided to produce a release warrant for some people who are being kept in jail, and that order was inadvertently served on counsels for these people by his registrar, who did not sign. I don't want to say he forgot. He did not sign. The law requires him to sign on pain of nullity. On pain of nullity. If he doesn't sign and he comes to serve, he himself serving knows that he is null and void. You see, that is the problem. Like you see, like you were saying, there is something wrong somewhere. Why did this boy not sign? As a registrar, he's been to Enam, he's been trained. They didn't pick him from the gutter. Why did he not sign? I said it previously. I blame the registrar in attendance for this quagmire, because he knows very well that everything coming from the inquiry chamber must be countersigned by him. But he decided to serve it on the lawyers without countersigning, thereby rendering a document null and void. So, if this document is null and void, you cannot make any use of it. And that is the reason why the public prosecutor wrote saying that the document has not gone through due process. The due process is that it has to bear the counter signature of the registrar. After that one, for you to enforce it, you still have it to take it to the prosecutor to also countersign. So he would not have even passed, because after the two have signed, they ought to send it now to the commissaire du gouvernement, who also has to countersign before they will take it to the prisons. So it has not undergone the due process. And if it has not undergone a due process, you ought not to have served it on the lawyers.
But now, let's look at it from the political cap. Who would even think of venturing into that for what end?
Venturing into what?
Wanting to
release the people.
Yes.
Well, it shows you that the judge is not a politician, because if he can take his pen and produce that and even motivate, because if you read it, you see that it actually comes from the court. For me, the fakeness is I can interpret that fakeness as being inappropriate. The inappropriate deliverance of the judgment, but not that it never came from the control. The registrar who served it is proof that the thing came from the chambers.
And that's even the councils have not counteracted. You
were saying they could be investigation. Which investigation?
The councils say they have discharge.
Yes.
Which says that they were served and they discharged. It means that it is authentic.
No, their signature is authentic, but the document is invalid. That's what I'm trying to make you understand.
The document is invalid, but authentic. Is it?
It was authentically served. You see, they authentically served an invalid document.
Okay.
That is the problem.
Very, very, very tricky one here. But does this also tell of the existence of camps at some levels? Because this is also a war of camps. There may be persons who may want these guys out, and then others who want them there eternally.
If you ask my personal opinion, I will tell you that from what I see, I have the impression that this judge was testing the waters, like you said, because you cannot give me one single reason why that registrar didn't sign. He was testing the waters. Is it proper for me to release this man now, these people now? He issues the order and tells his registrar not to sign, not to counter. I mean, he creates the defect. And launches it to see the reaction, and from the reaction he said, no, let me not there. I think, I mean, in my own interpretation, I may be wrong, but that is what I understand. He was certainly testing the waters, and after having got the talk of social media,
the boomerang effect was too high.
They got the reaction from social media, and it wasn't positive, so he decided not. Well, they decided to use the invalidity of the document.
Has he the competence to decide to release people not to release people if they are found not guilty?
Oh, we are not at the stage of trial, sir.
No, because you
this
say
is not the stage of trial.
You say he was testing the water. Testing the waters to do what? To release them now?
He has the power to release any person detained by him. He has the power.
Yes.
But being a sensitive case,
that is it.
The case is so sensitive. It was started by very, very high command. Now it is in his keeping. So if he just orders directly and say release them, and there is social upheaval, that would not be good.
Okay.
So I think he is using his experience to test the waters and see whether such an order can be entertained by the public.
Okay. We're going to take a short break to continue right after.
Les fêtes continuent chez Canal+. Réabonnez-vous à votre formule actuelle et bénéficiez du bonus incroyable de 30 jours offerts à tout Canal+. 30 jours pour profiter de plus de 400 chaînes et des meilleurs programmes. 30 jours de passion, 30 jours de foot, 30 jours de séries, 30 jours de films, N'oubliez pas, c'est 30 jours offerts à tout Canal+, en vous réabonnant à votre formule. Et si vous n'êtes pas encore abonné, le décodeur HD est au prix exceptionnel de 5 000 francs dès la formule Access. Alors, allumez votre décodeur et passez de belles fêtes en famille avec Canal+.
Welcome back. You're watching Prime on my Media Prime, and we are looking at the trends of events in Yaoundé, where an order is signed today, and in the evening it is countersigned by same authorities. We saw the President of National Assembly sign the dismissal of his Director of Cabinet, and read 3 p.m. on national radio, and in the evening we see another order signed by him, saying that what was read over national radio was fake. And here we find another order that was signed by a magistrate, and later on a judge, and later on we get information that it is fake. Fah Elvis Tayong, should we be expecting more of such fake information that comes out in the morning and in the evening debunked?
Yes, we should expect them if they are dealing with sensitive cases that have some interest from different angles.
Yeah, what does it tell of what way things are happening in Yaoundé now?
No, you know, as I said, it's a kangaroo system from the beginning. From the roads that are falling, the health system collapsing, the educational system limping on one leg. You know, it's just a characteristic to tell you that the center is no longer holding, and so things are gradually falling apart. I will tell you, for example, that if you look at what transpired, normally I said if we were in a country where there's transparency, there should be an independent commission to prop into it to find out the invisible hands. Because I will tell you, you and I cannot sit and muster that kind of courage. Now, just like what Senior Barrister said, if it was served without undergoing due process, it is still another legal lapses, which means somebody is supposed to bear responsibility. If I am a registrar, I've gone to ENAM, certified scholar, professional in that field, and I decide to carry on some a document without following due process until I am serving the different councils without due process and my signature, it means that I have every reason to be suspected, because it does not happen within the normal parameters in that line. So in that case, I would tell you that under normal condition, they are supposed to go under effective investigation, so that if, for example, the president's hand was behind, it will be known. If it was just the examining magistrate that took upon himself that's to execute alongside with the registrar, they are supposed to be brought in. And so at the end of it, I think that if we're talking about a country that has the rule of law, these things are supposed to be put in place. Because you don't issue a communique in the morning and the next few hours you are withdrawing it, and then you start attributing it for fake. That's why I said that even those who are at the regulatory board, they call them antique, are supposed to be brought in. Those are experts who are supposed to go through these documents, go through what was served social media. They are supposed to find out if these things that have gone through social media were actually the fake as they say, or they were passing through another disguise. Because at the end of it, experts need to be called in. If antique comes in, they'll be able to tell you whether the issue that went through social media was actually that different from another one that they are saying is fake or not. Now, if the due process of investigation is put in place, independent, I'm not talking about those ones that are always put in place and then results, you never get results. Because if you were, this is Donald Trump here, for example, let's go to American politics. You see the way he's passing under serious investigation, and his lawyer, and his attorney will tell you that no, he cannot be tried now, he has some immunity, and that judge tells you no, his immunity he's not above immunity. So if you look at it critically, those who falter with the law signing something which does not undergo due process, or delivering a particular document which has not undergone authentication, are supposed to also answer. The moment they cannot answer, it means that they were truly testing the waters. And on seeing the waters was the water was quite hot, they had to backpedal. And this is where I say that in a case where it is sensitive, you have these things that come up. If it were a case on normal persons like us, I think that you will see the registrar will be dishing out the document with the signature on it when it concerns Fah Elvis Tayong, because this one is a lightweight. But now that heavy weights are involved around it, and you asked the question before the break, could it be that there are some invisible hands or a fight somewhere? I will tell you, the case is unfolding, telling us that there are invisible hands. And as I said a couple of minutes ago, that the fact that I can put up a document wanting some person to be released without following due process means that I must be a man. To pass through the courts, I must be a man. If not, how do you dare with those kind of cases, knowing fully well that even at the level of the registrar there at the prison, they will equally be checked, because they have a process of checking. All of them have undergone that. You don't just get a document coming from the magistrate or the judge, and then you execute. You have to verify. Sometimes a phone call, sometimes other authentication to show that this document is authentic before you execute, especially in a case like this, which is very, very sensitive. So how they wanted to maneuver around it is only God who knows. But as I said, they tested the waters, it did not go. Since it did not go, they are supposed to come in to answer questions of who sent them to taste the waters before backpedaling their movement. It's very important.
Now, Senior Barrister, if you say the fault was that of the registrar, and let's take the case of the President of the National Assembly who says the other one was fake, why don't we investigate to know where these things are coming? What is the essence of that?
Okay.
How do we get this stuff happen at the highest quarters in our nation?
Thank you, Mr. Kum. You see, let me address first what the worries of the kangaroo man. No, there will be no possible investigation of anything concerning this matter, because everything that happens inside the inquiry, the judicial inquiry, is secret. So you bring any person to come investigate there, you are exposing the secret. So I don't think any investigation is possible. Maybe you want to come up with a disciplinary file against the magistrate, that is a different thing. Okay. But you say to come and investigate, no, forget that. That will not happen. Now, if you look at what actually happened, we are presented a document duly signed with a round stamp and a name stamp and the signature of the examining magistrate. Then he comes up with another letter to say, no, it is fake. And then that letter, the first one that he signed, the order, was served on the lawyers of the parties by his registrar. Mm-hmm. The first inference is that the examining magistrate is accusing his registrar. He is accusing his registrar as being responsible for the fraud, for the fakeness. Yeah. Now, it's a very delicate one. The registrar is washing his hands off by saying that I am not a party to the fraud. I'm not a party to the fakeness. Yes. You see, Mr. Kum, had the registrar countersigned that order, he would have been a party to the fakeness. Yeah. He washed his hands off. He served a document that did not bear his own counter signature.
The registrar?
Registrar!
Yeah, but we have here procès verbal de notification d'une ordonnance au conseil. This one is to the conseil of Amugu Belinga. This is it, signed by the registrar. This is it here. Then we have another one, procès verbal notification conseil. This one to the of Eco Léopold Maxime, greffier Nkwa Jean Didier, to the lawyers of Eco Maxime. This other one, greffier Nkwa Jean Didier, to the other, yes, but these are all signed by him.
We agree that he served that document that is being crafted as fake. He served the document.
Yes.
I am saying that. Now that the examining magistrate is saying that what was served is fake, he is in actual fact accusing his registrar.
Yes.
But the registrar,
being smart as he is,
play the first one by not countersigning the document that is that is indicted as being fake.
Yeah.
Yeah, but
Might not sign countersign, because had he countersigned it, at law it would have been a good document.
Yeah, but could the registrar not also, what is the essence of this document that the registrar himself served and signing?
They are useless.
Yeah, but
They are useless in that.
But they are coming from him.
Look, they can come from him. I say they are useless in that they are defective at law. He served a legal nullity on those people, and that's why I say my colleagues were not vigilant, because they were very anxious to see their clients out, and they didn't pay attention on what was being served on them.
Okay.
So for me, I think that the examining magistrate is accusing his registrar, but his accusation cannot go far, because he can't go far because the registrar washed his hands off by not countersigning. He is saying that I have served what I received. That's the language of the registrar.
What you are saying could also be very dangerous. Fah Elvis, good evening. We know you are watching us, and Awazi Emmanuel is also watching us. Tekung Clinton Abe is watching on our social media handle, and to you, Paul Kempes and Albert Abibi, all watching on the social media handle. Tell us where you are watching us from. Don't just say you're watching, but tell us where you are watching us from. Now, when you say the registrar washed his hands off by not signing this,
yes,
what does it tell? How can your boss issue an order and you refuse to sign? Is it to say that you do not believe in a decision that is taken by your boss? Because that's that's the implication of what you are saying here.
You know that the issue.
I said they were testing the waters.
No. If you say he's washed his hands, it means that he does not believe in a judgment that is taken by his boss.
Yeah, the issue
is that the role of a registrar? Is that the role of a registrar?
No.
Yes, it is his role. Now look, legally speaking,
yes,
this registrar is saying that thing was not taken in my presence, was not in my presence.
Yeah.
Because the law says that Article 1, section 153, the law says that he works with the registrar. So if the registrar sells a document that he receives from his boss and does not countersign, means that he does not agree with whatever is written there. It was not done in his presence. It was not executed in his presence.
Okay.
So I have served what I have received. I wasn't there when it was done.
Yeah.
Okay. Akuna Uba is watching us live from Los Angeles. Good evening to you. Now, National Assembly says what was read on national radio was fake. The magistrate, the judge Sikati says that what was circulated was fake. Don't we have a means to trace these fake documents? Because they should be coming from somewhere.
Yes, the means to trace is there. They say where the will is there, the way is there. I will tell you that since as it's a case that is complex and invisible hands present, just like what senior barrister said, they cannot be investigated, but it can be traced. But I think that the powers that be, even within the judicial corps, could equally be able to trace, because there's a possibility of tracing. There's a possibility of tracing where a document is coming from, because it left from office A to office B, from there to the councils, who came and also signed their own part, and so at the end of it, it can be traced because somebody somewhere wrote the things, somebody somewhere equally attested, even verbally, because even if the registrar did not sign at the initial document, as we're saying, but the fact that he issued to the council and the council were present, if the council are serious, they too could equally attest that no, he called us to his office and served us this document, maybe out of excitement. We did not go into details to look at the parameters of whether the authentication was fulfilled. We were excited probably to get our clearance out, only for us to realize later on that it was not authenticated through due process. So, but I think that at the level of investigating or finding out through the competent authorities, whether those within the inner chambers of that case or not, it is possible to trace. But then the question we are asking is, if we have the judge himself who comes and is backpedaling, now the question we are asking is, are we sure that sincerely he and co are not really aware of the waters they were testing? Then it becomes another ball game. But the main truth here is that If we look at it, let me tell you something from us who carry on with our analysis. The moment that document was there, other videos have been prepared. Other videos have been prepared in that light and edited. Bon, merci, j'ai donné 25 millions. No, what something million à tout le monde. You see, there was an applause. Another video was equally there, which showed that it was like it was being received in the village with a dirty shirt that tells you like it's coming from the. So you discover that the issue had been planned. I don't want us to behave here as if we never knew the mafia. Everything had been planned. That's why you see those videos were coming at the same time. Okay. And you see, it took me not less than 2 hours to work on that video to find out if this thing was actually real or not.
Okay. Hello, Mr. Liu. The document was not fake. It shows that the judge received instructions from higher powers not to proceed with the release. It's quite a shame. Alan is watching us from Rwanda. Glad to always read from you. Do you believe that he may have, maybe he respected almost everything, like you cited, that when you read through the documents, the decisions, it shows that it comes from him. It comes from a process that was duly followed. Do you also believe that maybe others came from higher quarters that, please hold on, and to justify, you need to also justify why
the others came?
Yes.
Well, I would believe so. Why? If you look at the case that was unfolding with Fondo of Balikumbat and John Contem, now I have quite a handful of friends who were at that time at the court there in Dop, who were handling the issue. I don't want to go further with whether who was there. I realized that each time the case was to come up, there were instructions that came up from the hierarchies. They understand what I'm talking about. They're watching me. They understand what I'm talking about. Before the case was now transferred, some judges there in Dop who were not wanting to dance to the tune were immediately transferred on that particular case, and not transferred from one section in Dop, but they moved completely from Dop and dispatched to other courts while the case was still ongoing. And from then on, when he took an appeal and the matter was transferred now to Bamenda, it was still another ball game because instructions came from different. And I will tell you without any prejudice that even back at the village, those who were supporters were even boasting. You know, it's like they knew the outcome of it. And if I will tell you that these are some of the cases that before you have it within the judiciary, there are orders that you get from hierarchies on even the judgment. Sometimes you have already judgment that is already prepared, so you will just be playing to the gallery. And that's why I said that from some of these cases that we follow, because the case of Fondo or Balikumbat, I followed that case as a young journalist who was aspiring at the level of investigation from DOP right up to Bamenda. And I was quite talking with a handful of the legal practitioners who were around the case and getting different versions as how it was unfolding. That's why the case was one of the most complex cases that you could find. Though everybody knew that this guy on a wheelchair, SDF district chair, was murdered, everybody knows, but then it was quite difficult to prove it within the courts because of the way it was unfolding at that time. Okay. So it's similar to what I'm saying here, that we would, from the way it's unfolding, documents are now fast showing that what they say was fake is not getting the fakeness as they purportedly told us. So at the end of it, I would tell you that invisible hands are obviously there. From the time the case was taking a different angle, from the time he was murdered, from the time it took time before arrest came in, I would tell even before the arrest of one of the suspect, he even boasted several times, you know. And so it took another center stage before he could be bundled out of his own residence with heavy so invisible hands are there.
Clinton NG is saying that I'm enjoying the program live here in Njombe. Chris is enjoying the program, and Chris Santos watching us from Batibo. Itia Brian is watching from Dubai. And good evening to all of you. I'll take a few messages while we continue with the program. Hello, good evening. I'm Chia Raymond watching from Bamenda. I'm enjoying the program. Thank you, Chia. This one says, good evening. I'm Charles Fonken watching from Kumba. I believe the magistrate and the registrar had collected money and scammed the victims. The accused had been scammed. Okay. That is also another angle we did not look at. Good evening, Mr. Liu, please. I'm a teacher and wish to ask why my media prime has not been talking about our struggle for the amelioration of the teachers in educational system of Cameroon since September 4th via OTS movements. We have discussed that severally and certainly are going to continue discussing in. Good evening, Mr. Liu and panelists on seat. I'm enjoying the program, watching from where? It's Auntie Lucy. Good evening to you, Auntie Lucy. Good evening, Mr. Liu. Musdan writing from Isokolo Limbe. No volume on the program. We cannot hear you guys in the studio. Okay. I'm sure there is a problem with your audio. Good evening, Mr. Liu. The topic today is very sensitive and interesting. It's good you brought Senior Barrister Ashu to talk about the cause. He is in the best position to make us understand the issue. Desmond is watching from Bamenda. Good evening to you, Desmond. Good evening, Mr. Liu. I'm marveled watching live the tact with which your wise team are handling such a sensitive issue. From Borno, this in Village. Okay, good evening to you. Interesting discussion. Greetings to Fah and Barrister Ashu. Afu Stephen Square is watching from Kuruku village in Batibo. Good evening to you. Okay. Keep the comments coming. Good evening, Mr. Kum. The maker is watching from Boya. Good evening to you, my brother. Long time. And we will keep. This is good evening, Mr. Liu. Good analysis there. Were the lawyers supposed to collect knowing that the registrar did not sign? Why did the lawyers not raise an alarm that the registrar did not sign? Wose is writing from Town of Friendship, that is in Limbe, who wants to distract Cameroonians. Okay, good evening to you. Yes, that is the issue. The lawyers are on the media every day. They are talking, but you are claiming that there is a fault. Maybe
I am not claiming this. The law says so. I have given you the backing. You see, Section 152, 53 of the Criminal Procedure Code, and legal a big book written by legal minds, by big legal minds in this country, who have analyzed the thing clearly and supported it with jurisprudence. It is not it's not Ashu. I mean, this is something which my colleagues ought to have known. They were negligent. They didn't open their eyes to examine the document. You see, when I look at that court order, there is look where you go up. It talks of section 222, because when the magistrate says, when the judge says it is a fake, that would imply that the person who served it knows where he got it. Yeah. All right. But when you look at the order, can the registrar motivate using article section 222? Because look, in matters of felonies, 224 proscribes, it forbids bail in this type of matters. It's not a bailable offense. But 222 authorizes bail. Now, this is what is cited there. Show you that the man who has written it is not a registrar, is a magistrate, and it's season 1. Because this is what 222 says. The examining magistrate, you ask a question, does he have the powers? The examining magistrate may at any time before the close of the preliminary inquiry and of his own motion, withdraw the remand warrant and grant bail. Where bail is not granted as of right or by the examining magistrate of his own motion, it may be granted on the application of the defendant or his counsel, and after the submission of the state counsel. When the defendant, after the submission of the state counsel, when the defendant enters into a reconnaissance to appear before the examining magistrate, whenever convened and undertakes to inform the latter of his movements. You now see why the state council came into play. Surely there must have been an application for bail by councils. That's why they were served. If council did not receive an application for bail, that order would have been served on demand directly in prison. That is, it came from the court swine moto. But this is certainly something that must have been powered or engineered by the councils. And as you are the man who asked, now let me give it to you.
Yes.
So you look at the motivation of it, section 222, that is something that is rare, because in many of the courts, people still find it difficult. You were talking of Gwagali
Fondo.
He is the person who started that jurisprudence.
Yeah. That
bail can be granted on that 222 in felonies.
Yeah.
His case was a locus classicus.
Yeah.
So you see, this man he may say it is fake. I say the fakeness is because the document is defective. Okay. But when you look at it, when he says it is fake, he pushes it into his registrar.
Yeah.
The law says registrar, when two of you sit and an order is produced, the judge signs, you countersign.
Yeah.
If the registrar does not countersign, there is a problem.
There's a problem.
It means that he does not, he is saying something. It was done without my presence.
Yep, presence. Yeah.
It was not done in my presence. I've only been asked to serve. That is what he is saying. I was only asked to serve. It was not done in my presence. Then, if we say that the order was issued subsequent to an application for bail by the councils, then it means that that application had gone to the legal department, which was aware of that application, and gave his opinion favorably.
And the document was now drafted.
What are we talking about? Where is the fakeness? The fakeness can only be, I think we are dealing here with very refined people. In my opinion, is that they created that legal loophole to serve as a rivulet, so that all the vapor from the steam will be passing, from the engine will be passing there. They must have asked this young man not to sign.
Okay. Good evening, Kum and members of the panel. Cameroon, our country, help us to identify fake documents. Okay. Good evening to you, Mabi Song, doctor out there in Kumba. Good evening, Mr. Kum, and those in the panel. With you, I'm very much impressed with the topic. So shall the separation of power start in full force? Let the Speaker of the National Assembly wake up from his sleep. I'm Taku Peter White, watching from Libreville in Gabon. Good evening to you, Mr. Peter White from Gabon. We hope you guys are all doing well out there. Good evening, Mr. Liu, and our able panelists represented. If I understand the whole scenario, it means there is power agitation within the main government body. As a result of this, it means all is not well, since maybe the head is void in execution, and every sector now wants to seize the advantage to gain power in executing. This can we see in these moves when you look at what happens at the National Assembly? Do you understand that maybe the President of the National Assembly may have been deceived that the big man says do this, and discover that this was not it, and then now how to backpedal? yes, and then with this also situation, maybe some persons were told that the big man wants this, and then later on, can we see the ping pong game as you usually describe now, how things are operating out there?
Yes, it's a ping pong game for sure. And the ping pong game will come because there is the clash of interest, there's a clash of power along the line. Now, whosoever calls a shot can equally will want to determine things at a particular point in time. We understand, like for the case whereby, because you will not be able to explain clean and clear that a communique, you take a decision, is sent to the national station, and it's read as per se, and the next time you are counteracting it. You know, as I said, if not that we're in the kangaroo system, like even the national station is supposed to sue those who call it fake, because when you call it fake, it means you're entirely saying that the national station went fake as well. Whereas it was served from their service to the national station to read. So if we're in a normal, officially, if we're in a normal country that is not kangaroo inclined, it means that the Director General of that national station is supposed to sue the President of the National Assembly for calling what they served him duly, because those that was dispatched. When it comes, because that's how it moves. If it comes, this was dispatched, we just need to show that A or B brought this thing to us.
It's like this ones. Yeah. The councils are presenting discharge of this document.
They have discharge that copy. Good.
That they received from the registrar. Are we saying that somebody impersonated the registrar or dressed like a registrar?
No, the registrar does not deny.
Yes.
He doesn't deny having served.
The good thing is that he did not deny having served. You got the point. It is just like
the Holy Spirit dropped this
it is the judge who says
yes,
it is fake.
Who says it is fake? But the registrar has not refused.
He has not refused
seeing that kind of document. So the same thing like what we're talking about, the issue of the National Assembly.
Yes.
If you look at it, the Speaker of the National Assembly only said it is fake. But he did not say that. He did not say that this thing was served or not served to CRTV. Now the question is, if you say it is fake, how did the national station
maybe some
hands on this to read it at the 3 p.m. news? So it means that along the line you could find that you want to vindicate yourself, but at the same time you are exposing yourself directly or indirectly. That's what is transpiring. So at the end of it, I said if we're in the normal system, we should have been keeping aside what Snr Bar is talking, which talk about they cannot be investigated normally, but I'm sure there's a way of probing into them in their own legal way and punishing, because people should assume responsibility. But then if they are not punished, it means that some power somewhere told them to test the waters the way they are testing. Because if you and I were at the level of that particular case, assuming that I was the registrar and you were the judge, I don't think that it would have been easy where we are sitting here. Because the first question is, how can you be a certified registrar from ENAM and you are sending out a document without countersigning? It means that they can investigate you, you know? I mean, in that case...
No, it was not done in his presence.
It was not done in his presence. Okay, good. Yes. So you now realize that for something to pass through my office and not being done in my presence, this shows that something is wrong somewhere along the line. So it is a very sensitive issue.
Now, when you say, Senior Barrister, that the registrar means that this document was not done in his presence.
He does not take responsibility for it.
It means that he says that what my boss, the decision that is taken by my boss, he does not trust it.
His duty is clearly defined by the law. If he has to accompany the examining magistrate, whatever order he's taking is in his presence. When it is done in his presence, he countersigns. So if he does not countersign, another duty he has is to effect service. If the examiner magistrate signs something does something somewhere and brings it to you, say go and serve, what should he do? He should countersign what he didn't see him do.
So somebody will simply go and say.
That's the thing.
Who prepared these documents, Senior Barrister?
Are you asking me?
No, they are signed by him.
The registrar prepared the notifications, and he is saying silently.
Who filled the documents?
I say he prepared the notifications, but he is saying legally. As for the court order, I was not there when it was signed. Otherwise, I would have appended. But I'm not appending because I don't know how it came about. In other words, he's saying that he didn't type that document. He did not prepare it. So he cannot append. Now, let us take some examples here. Because some people say there are some hidden hands up. Do you remember the case of Yonder Black? Before the same military tribunal. I was counsel in that case. And we were in the court. After all the addresses, the court went into recess for judgment. The judges left and went to the Unity Palace. We were in the court for almost 6 hours waiting for them to come back. When they came, they passed their judgment. Now, in one of the interviews, Eric Chinje asked the president why these people were convicted, whereas it was clear that their offense, the only offense they committed was wanting to create a political party. The president's answer was, ça dépend de la manière qu'on m'a présenté les faits. Meaning that he was accepting that the fire was brought to him. So I am saying by that very example that if the president wanted to know about what is happening, he will call this examining magistrate and say, come, bring the fire. So do you see him calling the man, say bring the fire, and then will tell him, okay, bring the fire, go and do like this. Then he goes to do it, say no, stop.
Senior Barrister, why don't you believe that the examining magistrate was maybe received by somebody at the presidency claiming to be on the instructions of the head of state and gave others, and this happens, and then things don't work out?
That means
must you be received in person?
That may be possible, but in a matter like this one, I don't see any person putting his hand inside of fire.
Because the fire is very hot.
The investigation he is calling with all his might will surely visit that type of person who dares to someone and because it is the president himself who talks to the magistrate, who gives his orders. So if he invites the magistrate and tells him do like this, I don't see him going back to say no, don't do.
Yeah, as the head of the judiciary.
Okay. Hello, Mr. Leo. The National Assembly is even better compared to the judicial system because at least the speaker made an utterance over his own case. On the contrary, the judge is still quiet. How then can we trust the judicial system of Cameroon? Max Begini, writing from Dusseldorf that's in Germany. Good evening, Mr. Kum. What is happening with CNPS? Raymond is writing from Boya. That's not our topic for tonight, no. Mr. Raymond. This one says, I don't believe what is happening in this country. Good evening. The program is wonderful. I'm Stanislaus Sati Ninos Ayong, watching from Mamfe. Good evening to you. Good evening. The program is wonderful. I'm watching you from Boya. Thank you. Okay, Mukwele says, greetings, Mr. Kuman, following the program from Bamenda. If I have to share my opinion from the legal perspective, those two are accused of committing a felony. Offense are categorized into three. Simple offense, here bail can be granted. Misdemeanors, here bail can be granted.
This is a felony.
Felony, here no bail is granted.
No,
cases,
222.
Yes, cases are high aggravated offenses like murder. I think the judge just realized himself and corrected himself. No. Thanks. Mr. Elangwe Robert Angowe is watching from Bamenda. Okay. I don't know whether it was bail or it was it bail?
No, they said main en liberté.
It's bail.
No, yeah, it was bail.
Self-bail. Self-bail.
Okay.
That's self-bail.
Okay. Dear Mr. Liu and the team, if they say the document is fake, they should tell Cameroonians where it is coming from. We have lived in deception for long. Nkwain Jacob is writing from Kumbu. Good evening, Mr. Kum and those in the panel. With you, I'm very much impressed with the topic. So shall they. Okay, he's talking about separation of powers. I read this one already. Good evening, Mr. Liu. It's Suzanne from Barombi Kang, Kumba. Cameroon government doesn't respect the law. The case has really exposed them. Greetings to all in the studio. Okay. Good evening, Mr. Liu. I'm watching from Bengui. Thank you for the analysis from Senior Barrister and my brother, the Kangaroo Man. Some of us are really learning much from your programs. More grace. Thank you. And good evening to all of you guys watching us from Ngusi out there after Tombel.
Yeah.
I hear most of you are watching the program and you are telling me that you want to create a Prime Hour fan club. I gave my endorsements already for a fan club to be opened up out there in Ngusi. Those of you watching, special greetings to everybody.
Can I say something, Mr. Liu? The Kangaroo Man raised a question. He said the people were being prosecuted for torture, not for murder.
Yeah.
Now, that gives the impression that torture may be lighter than murder, right?
Yeah. Certainly. For sure, you know.
I am sorry to disappoint you, Mr. Kangaroo Man. You see, murder only attracts a death sentence when it is capital murder.
Okay.
If it is capital murder, it attracts a death sentence. But torture occasioning death is punishable by death.
Okay.
So you see that they've opted for a heavier
sentence. Okay.
Okay, Mr. Liu, irrespective of the procedural or defective nature of the document, by the failure of the registrar in attendance, I think the decision of the examining magistrate is salutary. He acted in line with the law and his conscience. The pressure on him only came when his decision was made public. The examining magistrate needed not to consult any hierarchy in order to decide on his decision or order. Could this be very true, that he's followed respected everything and found these guys not wanting and actually felt the need to release them, but others came and pressure. Could this be true?
Let me look at that. This one does not concern what is happening in the case. I don't know what is there.
Yeah.
But as a lawyer, I will tell you that if I were to be examining magistrate, I will not release these people.
Yeah.
Mr. Kum, these are people who started by lying. I mean, from what we see as the reasons laid down.
Yeah.
Because the judge says that, I mean, the order, the purported order says that in his last deposition, this culprit cleared, some other culprit, co-accused,
Yeah.
cleared the people who have applied for bail. And that was the reason why they were being released. First of all, the Criminal Procedure Code provides that you cannot convict a co-accused on the sole evidence of a co-accused.
Okay.
First of all, you can't convict somebody on the sole evidence of the co-accused. Are we sure that in that file, it was only the sole evidence of the co-accused that was keeping them there?
That's the question.
First question. Secondly, if you have heard, you have taken about 5 statements from somebody, he started by lying 4 times, and then on the 5th time he tells you, oh, now this is the truth. Which of the statements is true and which is false? How can you consider the 5th one true when he has lied 4 times before?
4 times.
No. You see, look, it doesn't make sense at all. Because if I were the one, I will not release you. You cannot lie 4 times. It comes to the 5th time and you say, no, I was just lying. I was told to say so by this man. What shows that what you are now saying is true? And all the other ones that you said before are false. You see, so for me, this is a matter that ought to go to trial.
Yeah.
They all have to be committed for trial.
You are passing judgment there.
I say for me. For me, if I were the examining magistrate, I will send all of them to court.
Yeah, but maybe there are some facts that the examining magistrate has that you don't have. You are not privy to. Like you said,
I am not privy, but you see, I started by saying that from all what we have been hearing and seeing on social media about their statements, there are people who have been giving several versions. But you cannot say that this man was arrested because the other one said so.
No,
after so many statements, he now says so. So you should
Fah Elvis Tayong, let's look at the independence of the 3 arms of government. Where you see this decision that is taken, and then hours later, there is a reversion of order where persons who previously staged an action said, no, we were not part of this, and then we saw that at the level of the legislative, now in the judiciary. What does it tell?
Well, it's to tell you that the separation of power that many persons are preaching in the name of democracy in Cameroon is a farce. You know, most of us in the early days around 2004, 2005, during the period of lawyer SMS case, the famous lawyer SMS case in Kumba, that was another very controversial case.
I was there.
That's when I was just starting my career in journalism. It was very challenging. And I will tell you the kind of warnings we got daring into investigating in that matter.
I was counsel in the matter.
Thank God you are even here. And many of us had to back out because it was clean and clear that if you are moving into the matter and you are not taking the side required by those who were calling themselves those who owned Kumba at that time, then you could imagine now that he was the counsel. I'm sure if he's testifying, he will tell you how it was another jigsaw puzzle game. That sometimes they will tell that there's somebody ahead of a goat. Well, I don't want to go into that detail. He understands how those things unfolded there in Kumba. But it's to tell you that at some high-profile cases in the judiciary, you will just discover that the judiciary is not independent. Like as I said a while ago, in the low-profile cases that don't have any attachment to it or don't have any call for concern, there you realize that the judiciary is completely independent. But we have cited, as said, the case of Fondo, the case of lawyer SMA. This one was talking here, even the one of Yodo Black, which Snr Bar just mentioned. These are cases that tells you that invisible hands are always around. So if you are a judge in that case or examining magistrate, you realize that you have to be very careful, because decisions you take will determine your stay in the position wherever you find yourself. And you could imagine that it's easier for the executive to give you orders to take a U-turn in whatever decision you intend to take. I think I have quite a handful of justices now who equally have been able to tell us that they were not privileged to get promotions required because they did not dance to the tune of particular cases where some particular hands were in it. So I think it's not new to Carolinas who are watching us right away that it depends on the case. Politically motivated cases or cases whereby you have some high powers that have interest in it will tell you that they would obviously tell you or influence what to do. You imagine, for example, I had a justice who was in Bamenda sometime who told me that there was a case he was handling, and out of a sudden, some persons were sent with food items and other like to his house one afternoon, and he was asking these plantains, oil and other like, what is it for? And they asked him to calm down, only to explain to him why they came. And though he asked them to take the things back, but immediately things were taken back, he took off immediately because his life was they know what I'm saying here. So that's why we say that the executive becomes so powerful when interest is at stake.
Okay, good.
And so we have to acknowledge that.
Okay, good evening, Mr. Liu and Prince Richard, watching from Kumbu, Banso. Very interesting program. Thank you very much. Good evening, Mr. Kum. This is Barrister Eja Edwin Mbai. Why is it difficult for you to understand, Senior Barrister Ashu? Any court judgment ruling not carrying the registrar's signature cannot be enforced. It's defective, null and void. Please, Barrister Eja Edwin Mbai, I'm asking these questions for better clarity. I'm sure many more persons have understood because of the insistence and the explanations he has been giving. So just bear with me. That's my job to now. Good evening, man of God. Please, I want to hear from you. What is the mind of God concerning a married man? Okay, no, this is not the topic for tonight. Good evening, Mr. Liu and Prince Richard, watching from Kumbu. Okay, I'm sure I read that already. Kumdung Judge from Muya, in a normal political and legal system, this bench of magistrates were supposed to be fired for malhandling the law on such a critical issue. Kudos, Senior Barrister. In this case now, who is, so the registrar has washed the hands, the examining magistrate has washed his hands, and things go back to normalcy?
The people stay in prison.
No, I'm talking about them. Are you saying that actually you say there was an error?
Yeah, the error is that the registrar
look at
did
the implications
the
for the counsels for both parties and what it is costing.
That's why I'm advocating.
I'm saying that the counsels ought to have been vigilant, because even when they were called to come and discharge the order, they saw that the registrar did not say, oh, please,
yes, but you say there is an error on the part of the examining magistrate.
No, an error on the part of the registrar, okay, who did not countersign.
Who did not countersign?
Yes.
Now, what
and now when he was
should this registrar not be sanctioned?
Why should you sanction him?
For not doing his job.
No. He did his job. He did his job, and that's why I say this man is sending a message. I cannot countersign, because probably if that thing was done elsewhere and brought to him for service, he will say
there is error.
He will say, I cannot countersign something that was not done by
Senior Barrister, there is error, yes or no?
Error on the document.
Yes.
On the document, yes, there is.
And the procedure of delivery.
The procedure had no problem. The procedure of delivery had no problem. The error was in the making of the document. So the law says that
who takes responsibility for that error?
I think
who takes responsibility for that error?
The judge and his registrar should tell us.
But
was the registrar present when that order was being made? If yes, why did he not sign? If he was not present, then we understand why he refused to sign. He did not sign. His not signing must have been a refusal. On the other hand, he has the duty to serve. So if the judge comes with an order and says serve, what do you want him to do?
Senior Barrister, have you had occasions where you I don't know, an oversight of just a signature, thinking that you had done it? Maybe it is out of negligence thinking. Maybe this document was prepared, and you know how charged things are.
It doesn't happen, sir. It does not happen because look, one lawyer just reminded you, no judgment leaves the court without the signature.
No, I'm talking about the error. The problem is
if there's an error, there's no judgment, sir.
Who takes the responsibility? Because
the judge and his registrar, the two of them know what happened. The judge knows that he has to sit with his registrar, and if he sits with his registrar and signs, because we are together, if you sign, you pass it to the Rahman. So you cannot tell me that you sign and you don't see to it that your registrar signs. There is a problem. If the registrar does not sign, it may be a protest to say that it was not done by me.
Who takes responsibility for this?
But I think that one thing is for sure, irrespective of how we look at it at the legal, with the legal eyes, like what senior barrister is looking and the other barristers who are watching us. But in my own point of view, responsibilities are supposed to be accorded. Because if this is the due process, and we serve a document without going through due process, it calls only for suspicion. Because you cannot say that you never knew. I mean, as a seasoned, skilled magistrate, of that magnitude, you cannot say that probably
Vice President,
you got it. So me, I'm saying that, please, this is time we should call the shot. The registrar himself and the examining magistrate should answer. Yeah, they listen very well. Military court listen. Secretary of State Defense listen very well. Those guys in charge of that case must be able to answer. They should not come and blindfold us here. That time of blah 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 is over. Because as a magistrate examining, you know the procedure. That if you are in this case with the registrar, you cannot for the worst sit without him being by your side, like what Shunneh Barrister is saying. So if by error you sat alone and you were pushing a document now to the registrar to forward it to the to the parties concerned through their counsels, it means that the due process has not been followed. Then you, the registrar, if you collected a document that you have a say on it, for example, and you are forwarding it to the counsels or to the parties concerned, without you also verifying as received, without calling on your brother boss. But this thing I'm making like that, how is it? I'm not saying we have not arrived at this. If you don't follow the complaint, it means that you too have to answer. In fact, the registrar, examining magistrate, as I speak here, you will answer. You will answer. Secretary of State, Gendarmerie, Defense, take your responsibilities. Minister of Justice,
of Defense,
Minister of Justice, Minister of Defense. Okay, it's under military court. Yeah, yes. Minister of Defense, please. We are begging on you. If you don't come into this, it means that there was a game that was moving on, and it could even get another dimension without us knowing. So in this case, if people took money which we don't want to move to that direction, or there was bribery somewhere that we cannot trace, because the things happen in a way that you cannot be a professional as Mr. Kum, and you are giving a story without verifying. When you know that the ethics of journalism shows that you should have two sides of the story. Now you pick one story of Fah Elvis, and you don't go to verify from Senior Barrister Ashu his own version, and you balance on air. It means that you have already violated the ontology of the profession, and you have to go in for. So if they themselves as magistrates, as people of the legal profession, violated that, but Senior Barrister Ashu is correcting here. But I'm saying that the legal parameters that will require them to answer, and if not fired, should be implemented with immediate effect. If it's not implemented, then I will suspect the powers that be, that they too had a hand in it, and that's why they have allowed the examining magistrate and the registrar to go scot-free. If not, this is not a sensitive case for the examining magistrate, a whole person of that magnitude, Sikati and the rest to go scot-free. No, they have to answer. That is how it's supposed to be. Responsibilities must be accorded accordingly in this case, just like in any other. If I blow my grammar here haphazardly, Mr. Leo has been saying he does not take responsibility, and I say I take responsibility in whatever I say.
Okay.
If I'm taking, they too should take the responsibility with immediate effect.
Good evening, Mr. Kum. Today's program is so interesting with our kangaroo man and Barrister Ashu. I love the program. More grace to you. Kumba Stanley watching from Cape Town. Thank you. Good evening, Mr. Leo, and to Senior Barrister and Fah Elvis. I have learned a lot today from your contribution Noel is writing from Yaoundé. Good evening, Mr. Leo, Barrister Ashu, and the Kangaroo Man. May the good God continue to protect you people for your patriotism to this nation. Theodore Mengot is writing from Yaoundé. Good evening to you. This one says the registrar was mad not to sign because he didn't sign and has reasons not signing. Let him tell Cameroonians. Okay. Good evening. Nice program. The truth is that Cameroon is being ruled by some top gurus in guns in Yaoundé. Only God can help us. Ojong is writing from Anguti. Good evening to you. Good evening, Mr. Leo. Dongo Clifford watching from Yaoundé. Your program is very interesting. Greetings to the Kangaroo Man and Senior Barrister. May the Lord protect, bless you all. Thank you very much, Senior Barrister. Now, things are not. How do we now believe informations before when they are issued? Do we need to now take one day to wait until they are not counted before we believe them? From the way things are going.
Mr. Kum, this is very tricky because going by the criminal procedure code, the examining magistrate can have a press conference, or he can ask the state counsel, the prosecutor, to talk for him.
Yeah.
But the registrar, there's no provision for him to talk.
Yeah. You can only execute orders.
There is no provision for the registrar to give his point of view.
Yeah.
You see, that is where the trouble is, because he would have told us the truth. Yeah. I did not sign because this is what happened. But if he does, they will catch him down for revealing the secrets of the inquiry.
So only his boss has a say.
Only his boss has a say.
Yeah.
You see, that is where the trouble is. We cannot, I said it now, you cannot investigate. There's no way. So we only have to wait, like my good friend said. Let us see what will be done to them. If nothing is done, therefore there must have been a hidden hand somewhere, and they were simply doing the binding of that hidden hand. So if something is done, then we will now know that well, they acted on their own and they have to bear the cat. You mentioned something concerning bribe. I don't know who can take bribe and decide to vomit back.
It is possible. There's some bribes that have tons on them.
Where were the tons coming from? No, I don't think any person can be mad to take bribe in this type of case. Yeah. I don't think any person can try it. Yeah. I know that the judge called Sikati. I know him. Yeah. He's not the type of person who can. No, yeah. He can't do that.
Okay.
I know him. I mean, I've been around since 1987. I have done cases before him, and I know him well. So he is not the type of person who can go messing up with. Surely there is something which he should take to the air and explain. Okay. Just that communicate like that is not enough.
Okay.
Let him call a press conference and explain what happened.
Mr. Maurice, watching us from Gusi, I want to say special greetings to you and all the members of Apostolic Church of that village. But is this not also eloquent proof of the fact that some persons may be using the name of the President of the Republic to pass certain decisions in Cameroon? Maybe this one failed.
No, we've had that, Mr. Leo. It's not today. We've had several persons who make declarations and said, always call the head of state. The head of state. We are thanking the head of state. Even when the head of state has not even thanked them, the head of state has sent also. That one is a common phenomenon in the kangaroo system, that anything you want to do, even when it's wrong, you want to hang on the head of state, even when the head of state did not send you.
I remember the day before Agbobala and the rest were released on the orders of the President of the Republic. We had two high-profile persons who the previous day had said, like you are saying, that the head of state cannot intervene in this matter, that the judiciary is completely independent. But the following day, we had information that these guys will be released.
Yes, when cases unfold like this, people have their stance and their interest. And it will depend on where you are holding your own angle. And so some people will tell you that, no, they want to give the semblance that the judgment that whatsoever will come from there is to show that at least the separation of power, the judiciary is independent. But you see how it backfires the other way around, in that the head of state himself, first of all, he is the head of the judiciary. That is what is there. He's the head of the judiciary, head of the armed forces, head of the executives. So one man who's the head of the three arms of the government tells you that he can call the shot. So when a psychophant or a political adventurer gets up one day and tells you that the head of state cannot intervene here, it means the person does not even know exactly what he's saying, because the head of state has that prerogative as per the constitution puts in the 1996 constitution, if I'm right, Senior Barrister. And so wherever he is, he can get on one day and gives you immunity, gets on one day and influence from whatever angle. He has that latitude. And so at the end of it, people will keep thanking the head of state. Whether the head of state did it or he did not do it, we thank the head of state. Continue thanking while we are going backward. When you only remember we are in the abyss, I will ask some of you, are you thanking the head of state now? Of course, head of the judiciary can decide today, if you were to be taken to the firing squad, to say no, release that man. And who is that judge? Who knows that his boss, who is the head of the judiciary, is ordering him to take a U-turn he will not take? It means something is wrong with that kind of judge. So that's how it looks like.
Okay, we are going to be drawing the curtains for tonight's edition here. Thank you, Senior Barrister, for coming.
Thank you, Mr. Kum, for giving us the opportunity to address this sensitive issue. I want to greet the new militants of Reform Party. Yabasi, I salute you. Bomono, I salute you. Bamenda, I salute you. Keep it up. Hold it very firmly. Make sure that come election day, we shall be talking to the Cameroonians from it today.
Thank you to the Kangaroo Man for coming.
Yes, our convention is the height, the fever is getting up. We'll all be in Yaoundé at the sport complex there, of course. We know that we shall be there for the 9th and the 10th. It's going to be hectic, and the militants are mobilizing. Even from the northwest region, they too will be coming there. Kumba is also getting ready to be there. But above all, Mr. Kum, I think we'll be greeting the people of Gunoko village as usual, and the people of Mbengwi. You know, I told you sometime about the case of the DO, and finally that particular ban was uplifted. I think we were quite clear on blowing of that whistle, and finally the AGM of the Mekudaras Meta Cultural Development Association is holding where it was envisaged to hold, and I think we are thanking the DO for hearing our cry and getting softer on that so that we move there. So preparations are going on from the 14th to the 16th. We'll be at Ngenbo, we'll also be at Tugi. All is getting ready. Of course, we shall all be converging back home to give this cultural jamboree the grandeur it deserves. Thanks very much.
Good evening, Mr. Liu. Thank you and your team for educating the public and enjoying the program, though it needs a legal mind to actually understand the mafia going on. Thank you very much. Good evening, Mr. Liu. I have been admiring your programs. Can I please have the contact of Senior Barrister? Can you just write me when I'm done here, please? Hello, Mr. Leo. Good evening. Okay, you say the house is on fire. Thank you. Hello, Mr. Leo. I just want to say your guests in the studio are the best. I have learned a lot from Senior Barrister and Fah Pankeng Yafe, writing from Bangulan. Thank you. And to all of you who took time off to watch tonight's edition of the program, we are grateful. And to Eli and Desmond, thank you for producing. Tabit and Bryant for supervision. Stay blessed. Bye-bye.